May I permit to mention for upgradation on application, item number 376 of today's list.
Item number
376.
you are appearing on behalf of the appellant.
Appellant.
What is the application pending?
Limitation, section 5 application.
Section 5. Item 376 upgraded.
Lordship, 375, Lordship. I am paying for Lordship. There is application for Lordship stay. I am of the claimant that learned tribunal declined to pass any award in favor of the wife. Because of learned tribunal decline, there is the marriage not solemnized. But the under the impression 1/3 has been deducted by considering that he is the married person. But the evidence used by the father, yes, he is my daughter-in-law. But the learned tribunal ultimately come to a conclusion he is not the marriage not proved. Because of the wife of the deceased not appear before the learned tribunal, accordingly not pass any award in favor of the. So let's kindly pass. Kindly, I am paying application for stay and the additional evidence and the addition of party. So 3 applications I have filed. So stay is required.
All 3 applications for the claimant.
All 3 applications from the side of the claimants.
375 upgraded.
Lordship.
My lord, may I leave to mention my matter, my lord? This is 421 of the 2D list. My lord, this matter was earlier marked as FMAT 1201 of 2017.
Yeah.
And on the last date, my lord, it was taken up on 16th of April 2024, my lord, when the condonation application was allowed. And my lord, the stay application was fixed for today, my lord. And now this matter is appearing at the bottom of the list. My lord, it is a 2017 matter. The stay application is yet to be disposed of.
Item number 421.
421, my lord.
Mr. Roy is appearing on behalf of the claimant.
My lord, I appear for the Union of India. This is my appeal.
And what is the court?
My lord, the railway claims tribunal.
No. Item number 421.
Application. Yes, my lord.
422.
421, my lord. It is a FMA 570. FMA 570 of
Lordship, there is the different matter. There is a different matter. There is the Mr. Singh for the appellant. That is wrongly the mistake is appearing.
my lord, here earlier it is FMAT 1201 of 2017. Your lordship had passed an order on that day, my lord. That is the Union of India versus Phoenix Overseas Limited. So now it has converted into the FMA.
হবে না, ঠিক আছে?
ঠিক আছে 421 upgraded.
My lord, may I have your lordship's indulgence, my lord? This is a very simple matter, my lord, but yet I have to take your lordship's leave. This was disposed by your lordship, and accordingly, the award check amount for the awarded sum that is also ready, and the check is ready, but it is out of time by 3 weeks, my lord. Let an extension be given so that I can deposit the check
You are appearing on behalf
of the insurance company, my lord, because insurance company always pay your lordship. So I'm sorry.
to be mentioned.
My lord, may I permit to mention for an application for inclusion.
Okay.
And my lord, another matter, my lord, for upgradation, item number 192, my lord, page number 407. I'm for the appellant.
Yes, 192.
Yes, ma'am. It may kindly be upgraded, my lord.
This is already running in the list under the hearing
Yes, my lord.
after vacation. You come after vacation.
After vacation, my lord, upgraded. Ma'am.
No, after vacation you have to mention.
mention.
May I have my lords kindly to mention item number 292, page 413 for upgradation. 292, page 413.
292.
292, page item number 317, 317, page 414, the very next page. 317. And lastly, item number 292, 317, and 380. 38, page 4.
All applications.
All applications.
3 matters are upgraded.
Deeply obliged.
292, 317 and
Yes,
380.
38,
For any number.
page 480.
Yes.
Deeply obliged.
So may I permit to mention one matter? That matter already been disposed of. Mr. Singh appeared for the insurance company. So in presence of Mr. Singh, Lordship, I am mentioning the matter. Mr. Singh can demonstrate the fact correctly. But Lordship, the insurance company deposited the award by deducting TDS. The insurance company deposited the award in the name of the Registrar General. But after deducting TDS, this is absurd. Who will pay the tax? You kindly also informed by Mr. Singh, so kindly after deduct, so the Registrar General will file income tax, then that amount go to the income general. But
Okay, very well. Do we mention?
Lordship, may I be permitted to one matter? Lordship, it's a dispose of matter. Allah Sheikh, that matter, the respondent authority, Central Railway, they are ready to pay. But within a stipulated time from the passing order, they were not able to transfer the amount to the Registrar General. Unfortunately, they have been transferred that said amount to the Registrar Bench, Kolkata, RCT, Railways Claim Tribunal. So they are ready to pay, but after that we have been communicated with the Registrar General Office and they have been told that a fresh order is required for giving to IFC court and another.
Whether you have deposited the amount
Yes,
with
yes.
the register of the tribunal.
That has been transferred. They will be now fresh, they will be transferred to the Registrar General, Kolkata Bench. So I have been applied for the IFC code and another. So from the Registrar General office, they have been told me that you have to be mention it and further fresh order is required for that.
My lord, yesterday, day before yesterday, I mentioned this matter. I am for the appellant, my lord. Wrongly, they have, my lord, transferred the amount into the registrar RCT bench, my lord.
Kolkata.
Instead of, my lord, Registrar General High Court, Calcutta. That is the problem. But your lordship's direction was that the amount to be secured before the Registrar General High Court, Calcutta.
Yes.
So they have to, my lord, satisfy your lordship's order to deposit the same before the Registrar General High Court, Calcutta. Whatever maybe they have done wrong,
Okay,
that
do-
is
do we
their
mention?
part, my lord.
Do we mention?
My lord, you also already directed the matter would be taken up as to be mentioned.
Yes, do we mention?
To be mentioned. And the Registrar General Office does not disclose their IFC code number and such matter. That is the problem.
Grateful, your lord.
That's it.
Madam ka bolte hain.
That's it. Let me mention that's the inclusion of the review application.
You are too late.
Lordship, fact is that your lordship disposed of the matter, Mr. Singh and Mr. Imam Ali is there. Lordship, I am the lordship's widow. Lordship, but without serving any hearing copy, lordship, the matter has been disposed of. Where tribunal lordship did not consider to lordship award to the father, but lordship without hearing me, lordship, that your lordship's
You are appearing on behalf of whom?
widow, Clement.
You have not been served?
No,
No, you have been served. I have
No,
seen
not-
the record. I know
lordship,
the
hearing
matter.
copy not served. Lordship, initially said stay application is served, but lordship, the matter
of
is
appeal
taken
was
up
not served?
hearing, that is not served without, not, lordship, paper book also not, lordship, not served. I am telling lordships. And there is a gross, lordships,
Yes. Lord, kindly me not keep it as to be mentioned. Because my lord,
Imam.
Mr. Ali Imam Shah, my lord, he was for the father. Your lordship decided that the father is also entitled to compensation. My learned friend is for the widow. My lord, the learned court below, my lord, granted entire money to the widow, did not grant any money to the father. So, my lord, he was here before your lordship, and it was my appeal But my appeal was quantum, Lord. I said I'm not interested whether widow gets or father gets their entitled compensation. Your lordship will decide. He showed to your lordship the evidence that she has been served. I mean, the widow has been served. On that basis, your lordship proceeded. I did not check the records. If she has not been served, your lordship will kindly see to it that that matter is taken up again, and whatever is correct, whoever is legally entitled to should get. There should not be any confusion.
Have you served upon the Mr. Imam Ali?
Lordship, I am not served, but
Then
I have.
Why are you mentioning without serving? Or dispose of matter?
Lordship, fact is that I have checked the, where is the file, Lordship, my learned friend so hurriedly, Lordship, applied before the, Lordship, ledger sections, and now bank has been, they disbursed the money in this case.
I am not asking anything. I am asking
I
whether
have,
you have-
Lordship, but the file should be
whether
ready.
you have served.
Yes, Lordship, I have talked him. He has not come, but Lordship, already I have talked him. The matter will be mentioned, we will discuss later. Lordship, I have taken in presence of learned friend, Lordship, we have talked.
No. You have to serve before
So I will
mentioning.
just be your Lordship is directed, I will serve. Before Lordship's hearing this matter, definitely I serve, Lordship. Lordship, your
Have you served the review application? No.
Lordship review application, Lordship is ready. I am ready, Lordship. Without certified copy, the not
So you
granted.
want the
That's
leave-
why leave. Now I want to leave, Lordship. Can't leave, Lordship, kindly. But Lordship's fact is that after disposing the matter, immediately Lordship sent before the ledger sections.
Certificate copy nahi kiya. Review without the certificate copy. You file the leave, you file the review, thereafter you mention, after mentioning, after service.
But Lordship, I will start words, Lordship, my learned friend, in the meantime, Lordship, all procedures complied to withdraw the money. If it is happened, then what will be remain, Lordships? That's why, Lordships, this is so urgent. Lordships, kindly file should be placed before your Lordship.
You file review first,
Today I will file.
then you file it, thereafter mention it.
Lordships.
My lord, may I be permitted to mention item number 378 at page 480, my lord, for upgradation of application, my lord.
Mr. Singh, upgraded 378.
I'm grateful, my lord.
My lord,
Yes.
upon mention, upon service to the other side, I'm mentioning this matter. My lord, your lordship is having the determination of court number 32. My lord, the next date below in the next date in the court below is on 5th June. My lord, there was a liberty granted by Justice Chaudhary that if situation so arises, we can pray for stay, my lord. My lord, the lower court is proceeding with the instant matter, my lord. Next date is on 5th June, which is during the vacations, my lord. And your lordship knows, my lord, court 32 is not sitting till 24th, my lord. My lord, any day subject to your lordship's convenience if this matter
You
is
are
taken up.
appearing on behalf of whom?
Petitioner, my lord. I've served upon the other side, my lord, the state and the private opposite party, my lord.
So you want the stay?
My lord, Mr.
But the
Bhattacharya,
stay is there?
my lord, there was a liberty to pray for stay if situation so arises. My lord, Mr. Bhattacharya
What
shall
situation
satisfy.
arise?
My lord, the lower court is proceeding with the instant matter, my lord. Matter relates to land, my lord, wherein the petitioner's parents were the lawful owners, my lord. The Gram Panchayat and other people were forcefully acquired into the land, my lord. There was a writ petition which was pending, which was there, my lord. It was disposed of. They did not comply with the order, my lord. Subsequently, this CRR was filed, my lord.
CRR for what?
My lord, CRR for stay of the lower court proceeding, my lord, because they filed a false and frivolous case against me, my lord. Me and my parents, my lord.
Then why you not file the application for stay on the initial stage?
My lord,
You have been-
we did pray for stay, my lord.
But it was turned down.
No, my lord. There was a liberty granted by Justice Vivek Chaudhary that if situation so arises, we can pray for stay, my lord. My lord, the first order is a detailed order, my lord. If your lordship goes through the order, my lord, I have not annexed the order, my lord. But Mr. Bhattacharya shall.
Urgency prompted you to move before this court.
My lord, on 5th June is the next date,
Maybe
my lord.
5th June, there are another dates were there also in the
My
lower
lord,
court.
if it proceeds on 5th June, my lord, this CRR will be infructuous, my lord.
No. In the lower court, there are other dates also in this way. What
My lord-
prompted you to file this stay application now?
My lord, this matter was heard, my lord. This CRR was heard, my lord, and there was a liberty granted by Justice
It
Vivek
was
Chaudhary.
heard?
Yes, my lord, it was heard. CRR 615 of 2023.
Then
But
how can I heard again?
My lord, I'm praying for stay, my lord. My lord, there was a,
Understand, the matter has been heard, you say?
my lord, it was heard by Justice Vivek Chaudhary as his lordship.
So now you are moving this matter after
My
so
lord,
many days.
My lord, this
So
could,
I want, what is the urgency now?
my lord, the urgency is that, my lord, 5th June is the next date before the
If
court
giving
below.
the
My lord.
5th June is the date, thereafter, there before another date would be there in the lower court.
No, my lord, that's the next date on the in the lower court, my lord. And
The
24th,
earlier date,
last
earlier
date.
dates, there are also some dates in the lower court.
No, my lord, for
So
this
what is
matter,
the
my lord,
proceeding going on there in the lower court?
my lord, for this matter, the date is fixed on 5th June, my lord.
What is the, what is the purpose? The 5th June is fixed before the lower court, do you
My
know?
lord, for hearing, my lord, for
Hearing
hearing
of
of
what
the
matter?
of the instant matter, my lord, against which we've come up before this court, my lord.
Why it was fixed 5th June before the learned court?
My lord, for hearing, my lord, I mean, the lower court matters.
Hearing means final hearing or anything?
No, my lord, hearing
The
of the
matter there you want to
my
stay.
lord, next date is fixed for framing of charge.
Framing of charge.
Framing of charge, my lord.
You can say so. Framing of charge is the date. Lower court shall not proceed if the matter is pending before the Honorable High Court.
My
They
lord,
shall not proceed.
my lord, if your lordship just sees this order, my lord, I don't have a soft copy. I have the soft copy of the my lord. It took my lord.
Okay. To be mentioned.
To be mentioned. The grant application file is in the department. Department.
Yes.
Code 30.
My lord, with regard item number 237 of today's list. But I mentioned this matter last Monday, your lordship allowing my mentioning and upgraded them and my lord directed that the matter to be taken up as upgraded matter. My lord. Only my lord short thing, my lord, for calling for LCR and formal order of admission and preparation of paper.
237 upgraded.
It will come tomorrow or any day, my lord.
Let it be upgraded. And the list of application, it will be upgraded.
May I,
Taken up one after another.
may I be permitted?
337 or 237?
237. 237.
237.
Yes, my lord.
Is it hearing matter?
It is hearing matter, but
No, hearing matter cannot be upgraded.
no, only formal admission, my lord. Formal order of admission is required for calling of LCR by special messenger, cost, and my lord, for preparation of paper book, my lord. Nothing more.
237.
237. It may be, my lord, under the heading application.
Yes.
As updated matter.
Under the heading of hearing, it is.
Hearing. It is appearing under the heading hearing, but nothing has been done till
Under the heading application.
my lord.
May I be permitted to mention a matter before your lordship? The matter is running as item number 61 in the daily list, my lord. And my lord was pleased to order the matter for after vacation, my lord. I'm praying for upgradation and fixing a date, my lord, before vacation.
Before vacation,
My lord,
it is running in the list.
my lord.
Item number 61.
61, my lord.
Perhaps it was called on the last Friday.
My lord, it was missed,
You are
my
not
lord.
there.
My lord, I was engaged in courtroom
Then
number
how can
14.
I accommodate you? I called the matter for hearing.
My lord,
Mr. Singh was there. It was called on the last Friday.
my lord.
And it would be again called on Friday, this Friday. You ready on this Friday? This will be taken up.
My lord.
I usually take up the hearing matters on Friday. Your matter is coming on the 5th. Yes, 5th or 6th. 5th. It will be taken up on Friday. No issue.
My lord. Grateful, my lord.
Not necessary.
May I be permitted to mention about these 5 cases which have been assigned by the Honorable Chief Justice to your Lordship?
What cases?
Original side. The original side. Yeah, original side.
What are the matters?
My lord, item number 1 is an execution case, and item number 2 is a section 37 application, and the rest of 3 items are section 34 applications, my lord.
So what is the urgency there?
My lord, the urgency is two of the respondents have already been admitted under CIRP under IBC 2016. Only one respondent is left out. He may also slip into CIRP any moment. I'll be left with a paper award only.
No, there is no chance of me slipping into. I am appearing for one of the respondents in some of the matters, my lord. There is no chance of me slipping into CRIP. I'm a healthy, functional company. And I, subject to my learned friend, my lord, I don't think there's any urgency in this matter, but I leave it to your
The healthy
lordship.
company is not paying the award amount also, in spite of there is no stay. He is not making any payment of the award.
Because it's under challenge.
Execution.
I beg your lordship's pardon.
Prefer the execution.
Yeah, I have.
Yes.
Then you proceed with the execution. What is the?
He's got money also from me, my lord, pursuant to invocation of certain bank guarantees.
The award was passed in the year 2016. Now the interest has come to about 15 crores. That also he is not paying. And he says, I'm a healthy company. Two of his good companies have gone into CIRP.
I will kindly take these matters up any day post the vacation, my lord. We'll make our arguments.
May I humbly submit that the section 34 applications could kindly be specially heard before the vacation, my lord. I'll be highly obliged.
Section 34 applications, my lord, they're very heavy matters. They'll take some time.
However,
I am led by my lord, Mr. S.N. Mukherjee in the section 34 applications.
At least item 3 and 4 if it could be heard, my lord, before vacation.
running last week, 4 days is there.
That's
I want to accommodate you. Just a
My lord.
Okay.
What?
ठीक है. Let me start. All the 5 matters would be listed on 22nd of May at 2 p.m.
My lord.
Okay.
My lord.
Let me see how it is going on there.
I'm grateful, my lord.
Grateful, my lord.
For judgment, Jalpaiguri matter for judgment, item number 1.
সার্কিট বেঞ্চ জলপাইগুড়ি হ্যাঁ না 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 যেটা আছে ওকে Vinod Kumar Agarwal versus Messrs. S. Serum Analysis. I am reading the only operative portion of the judgment. Subsection 3 of Section 7 of West Bengal Premises Tenancy Act 1997 enumerated consequences of failure of a tenant to deposit or pay any amount referred to in subsection 1 and subsection 2 within specified time or within such extended time as may be granted. Full stop. Learned advocate for the petitioner submits that subsection 3 mentions the extension of time, extension of subsection 1, as well as in the subsection 2 of the said act. I find no justification in the submission of the learned advocate for the petitioner, as provision of extension of time is only provided in subsection 2 of section 7 of the said act. Moreover, subsection 1 has no provision, and the colon mark mentioned just before the proviso of subsection 2 makes it clear that the proviso is only in respect of subsection 2. Considering the all aspect, I find no justification to entertain the CO. The impugned order passed by the learned civil judge concerned appears to me justified. The instant CO be dismissed and disposed of. Connected applications if pending are also disposed. Next. Display.
Mainland matter to be mentioned, item number 1 and 2.
Yes.
My lord, this is the appeal of
appealing for the claimant respondent, Your Lordship.
My lord, this is the appeal of insurance company. My lord, the point being confined, my lord, only to the quantum, my lord, we jointly paid before your lordship, not that it can be disposed of. My lord, the facts are, my lord, pursuant to the order of this honorable court, my lord, I have deposited the entire compensation amount along with interest before my lord's court. My lord, one bachelor, my lord, while going on a motorcycle, my lord, met with an accident and died.
Yes.
My lord, two vehicles were involved in the accident. So there was a truck, my lord, which was insured with United India. My lord, Mr. Paul is appearing on behalf of United India. And my lord, there was a trailer, my lord, insured by my client, the appellant before your lordship.
Yes.
My lord, these two collided. Ultimately, my lord, they hit the victim. Victim died.
Okay.
My lord, learned tribunal judge, on a claim application, my lord, filed by the heirs of the deceased. The parents were, my lord, the claimant since the victim was a bachelor. My lord, assessed a compensation of rupees, my lord, 11,92,000 in principal, along with interest, my lord. My lord, in the claim application, my lord, it was alleged, and as well as in, my lord, in the FIR, that both vehicles were equally responsible.
In the FIR?
In the FIR.
Yes.
My lord, in the claim application also, my lord, the allegations have been made against both the vehicles.
Yes.
My lord, the eyewitness
Yes.
stated, my lord, both the vehicles were responsible. Only in the charge sheet, my lord, it was alleged that the vehicle insured by the appellant, the Sriram General, my lord, that was responsible. So, my lord, the FIR as well as eyewitness said both were responsible.
Yes.
And my lord, charge sheet said that only the appellant before your lordship is responsible. Be that as it may.
Yes.
My lord, assessment was made. And my client, the appellant today, was asked to pay the compensation. My lord, I will not invite your lordship, my lord, to go into further gory details of this because Kenya is against me. My lord, the claimants have the liberty to go against any of the tort fees, my lord. And the learned court also, my lord, can pass order against any one of the tort fees, my lord, and against any one of the vehicles. And then, my lord, it can say that as far as the apportionment is concerned, you go, you fight it out, and then you decide, my lord, who is what, who is not. So today, my lord, I would not invite your lordship, my lord, to get into this. My lord, I shall be paying the compensation amount. My lord, there is a little dispute with regard to the quantum. My lord, I'll indicate to your lordship. My lord, ultimately, my lord, I'll be only praying for one thing. My lord, your lordship will kindly grant me that liberty in view of Kenya, my lord, to take appropriate steps in accordance with law to prove, my lord, the negligence on the part of United Struck. My lord, I will not trouble your lordship today with any further of this. My lord, I sincerely believe, my lord, my learned friends would not have any difficulty in that because, my lord, appeal would be disposed of. My lord, now coming to the quantum part, my lord, where, my lord, I join issues with the learned tribunal. My lord, deceased was a bachelor. My lord, first point, my lord, deduction of one, my lord, the parents were the claimants before your lordship. My lord.
Deduction was 1/3.
Deduction, my lord, was 1/3. It should be half.
Half, Your Lordship. 50%.
Yes.
My lord, second point, my lord, general damages, my lord, the consortium was granted and it was made to 70,000. My lord, it is incorrect. It should be 30,000. And my lord, with 10% increase, my lord, it would be 33,000, if I'm not wrong.
Lordship, 20% also it would be 36,000.
36,000.
judgment
36, ho gaya. My lord, 36,000. I'm not on that. My lord. Instead of 70,000, my lord, it should be 36,000 because it's now 6 years. Third point, my lord, on the on quantum itself. My lord, the future prospect of 50% was granted. My lord, victim was a civic volunteer. It's a daily wages earner, my lord. Civic volunteer. It should be 40%, considering the age of the deceased. My lord, these are the 3 points in appeal for deciding the quantum, wherein, my lord, I join issues with the learned tribunal judge. My lord, deduction should be 50%. General damages
Yes.
my lord has taken note of, my lord. Deduction should be 50% instead of 1/3. Second is, my lord, the general damages should be brought down to 36,000 instead of 70,000. And my lord, third point was, my lord, the future prospect, which was granted 50%, it should be 40%. My lord, these are the 3 points in my appeal as far as the quantum is concerned. My lord, my learned friend on behalf of the claimant, my lord, has filed one cross objection. My lord, learned tribunal judge granted 4% interest. My lord, it should be 6%. I do not dispute that. My lord, on that basis, my lord, we humbly pray, my lord, on the basis of this calculation, your lordship will kindly dispose of this appeal. And my lord, as far as, my lord, this negligence part was concerned, my lord, in order to avoid any confusion, my lord, I'll just indicate that particular reference which learned tribunal judge has held that yes, the eyewitness said that both were responsible. So that, my lord, there should not be any ambiguity. My lord, I will just invite your lordship, my lord, to the memorandum of appeal, my lord, and the award annexed to that. My lord is got it, my lord. My lord, internal page, my lord, 8 of the award. Well, I'll just take my lord to that referral, my lord.
Yes.
Yes, my lord, there, my lord. Internal page 8, paragraph 12. PW2. Baishagu Sinha. Shingo. My lord, here's the eyewitness. My lord, I leave this entire paragraph. Your lordship will kindly come, my lord, to the last 2 lines. The evidence of PW2. Accident took place due to the reckless and negligent driving on the part of the drivers of the truck bearing number so-and-so, that is, my lord, Mr. Paul's client, and the trailer number so-and-so, that is me. That at the place of the accident and road so-and-so, my lord, this paragraph ends with the sentence, hence, the drivers of both the trucks were absolutely responsible for the alleged accident. The victim had no latches on his part. Paragraph 13, my lord. I'll just continue. The post-mortem report reflects that victim died in the accident. It appears that on 28th June, the complainant, Vishwanath Singho, lodged a complaint at police station against the drivers of the offending vehicles, number so-and-so and so, for dashing his brother. And my lord, it continues after 2 sentences. The PS case number under section so-and-so had been registered against the drivers of the said offending vehicles. So, my lord, as I stated, my lord, at the very beginning, my lord, these are the facts.
Yes.
But, my lord, today I would not be troubling your lordship, my lord. I'll just pray for your leave from my lord, my lord, that your lordship will kindly allow my client, my lord, to proceed in accordance with law for apportionment of the liability between both the vehicles, nothing more. My lord, these are my submissions, my lord.
So I find the court, your lordship, the interest fact portion also already my learned friend submitted, your lordship. It was granted 4%. That should be at because the payments the old percentage and your lordship the funeral damage that should be increased by 20% because already 7 years before. After passing the delivery of the judgment, judgment was delivered on 31st October 2017. So it is it's a 7 years of already passed 20%. So 36,000 and interest at least will be 6%. And also another fact also the picture pocket. The learned friend says it's not a permanent job, but also the civic volunteer, they are getting job regularly. So, and they are getting money from the government itself also. So,
But it is not a permanent job. It is not a permanent job, you know.
but maybe also 40%.
They are maybe permanently engaged, but that is not the permanent job. Yes, Mr. Pal.
Yes, company the point things are taken the digest of therefore the duty of the company it is the insurance and owner of the both company. But the claimant has it is 1%. So the claimant has the right to fight against of the joint. Another insurance was not here. Here, in that insurance, yes, very well. If the presentation, we are directly inviting the I separate who national negligence right or the apportionment of the
Compensation.
what are you? Here to learn. Here that is not happening because here were involved two insurance companies were here to owner was not that one vehicle owner of the vehicle has been made party of one insurance that another insurance company has got some chance to contest their that is not happening. Who here two owners were two insurance companies were charging fees get have charging fees and judgment one charging fees the both the way.
Yes.
The both the way. Yes, the charging one have considered the case. Charging fees even the investigating officer after taking all the permit after taking a statement under 50 months issue charging against the driver of the trailer. And on the basis of that, and on the basis of material of record, that the managed tribunal said that yes, charging is correct, and the same generation
Okay.
Lord, may I just, if my lord so, my lord, pleases, my lord, I can just give reply to that in 2 lines.
Yes.
My lord, my learned friend has stretched the argument. He says that no, forget about separate proceedings, let's go to the Kenya. And he also says that on the basis of charge sheet, he is not negligent. He is forgetting that the claimants alleged that he was responsible. He is forgetting that learned judge came to the finding and the eyewitnesses said that yes, he is also responsible. So herein, Kenya would not be applicable. Your lordship will kindly apportion the liability 50-50 on both the vehicles on the basis of the evidence produced, on the basis of allegation made, on the basis of FIR. Your lordship will kindly do that, and your lordship will forget about the other independent proceeding, what I had paid before your lordship, for disposal of this appeal. Your lordship will kindly decide. Your lordship will kindly decide. May I just speak? Your lordship will kindly decide that yes, on the basis of evidence, because the finding of criminal court, it is not binding upon the civil court. We are not relying upon charge sheet in all the cases. Eyewitness is here before the court. Eyewitness says both are responsible. Your lordship will kindly, decide this case that yes, both are responsible and apportionment should be 50-50. I shall not press Kenya. I will not pray for the independent proceeding against the United India.
I do not have any all the documents.
I agree.
Because
I agree. I agree. Paper book चोरी कर रहा हूँ.
Okay, hard. Please take down.
তুই করেছিস তো?
The instant appeal is preferred against the judgment and award dated 17/9/2019.
এ বাবা, মালিক কার্ড পেটে কার্ড, ঠিক আছে?
Passed by the learned judge,
হ্যাঁ?
Motor Accident Claim Tribunal, ADJ, FPC, First Court, Islampur, Uttar Dinajpur, in MSC case number 33 of 2017. Stop.
ছিল রে। আর 27 মালিক तो रिकवर करेंगे 50 रिकवर करेंगे, देखो नहीं तो ज्यादा हो जाता है।
The brief fact of the case is that on 28/6/2016 at about 6 p.m. the victim of this case, namely one Parimal Singh, along with one of his friend, was proceeding to their residence at Chunada, দেখেন একটা CHOUNAGARA, Chunagara, Kuatuli, QUATULI, under the jurisdiction of Korondigi PS along NH 34. When they reached at Salampur, at the time, one truck bearing number WB 59/5973, which was coming from Raiganj side and proceeded towards Korondigi, and another trailer being number NL01G/3781 was coming from Korondigi side towards Raiganj, and both of the vehicles were running in a very high speed and rash and negligent manner. Consequently, they collided each other and it was a head-on collision. After such collision, both the vehicle dashed the motorcycle of the victim. As a result, the victim and his friend were thrown up on the road and sustained severe injuries on their person. After such accident, they were admitted to the local Korondigi BPHC. Thereafter, they were referred to Raiganj District Hospital. But the victim died on the same day at night. Full stop. Next para, the parents of the victim. Now, victim was a bachelor. Victim was a bachelor. The parents of the victim preferred an application before the learned tribunal under section 166 of MB Act for getting compensation on the ground that the victim died due to rash and negligent driving of the drivers of both the offending vehicle. Full stop. Both the insurer of the offending vehicles made party in the proceeding and contested the claim case by filing written statement. The learned tribunal, next, after hearing the parties and after receiving the evidences, awarded a sum of rupees 11,92,000 towards the compensation and directed the present appellant, that is the Serum General Insurance Company Limited, insurer of the trailer bearing number NL01G, capital G, stroke 3781, bracket 12, to pay the compensation, to pay the entire compensation. Being agreed by and dissatisfied with the said award, the Serum General Insurance Company Limited has preferred the instant appeal. Full stop. Mr. Singh learned no. The claimants has also preferred one cross appeal against the said award, and being court number, what is the court number?
Milord, court number
16. Court 16 of
Court number, your lordship.
16 of 23.
16 of 23.
16 of 23. Let both the appeal and the cross appeal be taken up together for uniformity of the judgment. Mr. Singh, learned advocate, appearing on behalf of the appellant, submits that the impugn award passed by the learned tribunal is erroneous on the point of quantum. He submits that the learned tribunal has considered the fact that both the that the parent that the claimant was the victim was the bachelor and the claimants are the parents, instead of which the deduction was made 1/3. In this case, the deduction should be half. Further point out that the learned tribunal has awarded future prospects, which was added as a 50% to his established income. The deceased was a civic volunteer, so he is not in permanent employee. He is not under permanent employment. Thus, in this case, the claimants are entitled to get only 40% to the established income of the deceased towards the future prospects, as per view of the Honorable Apex Court in National Insurance Company Limited versus PROCEEDINGS. It further submits that the learned tribunal has awarded general damages of rupees 70,000. In this case, the parental consortium was awarded to be 40,000. The Honorable Apex Court in PROCEEDINGS has specified that the consortium is available only to the spouses. So in this case, the parental consortium is awarded excess. Banerjee, learned advocate, appearing on behalf of the claimant, submits that the learned tribunal has only awarded simple interest at the rate 4% per annum from the date of filing of the claim application. The interest is in the lower side, so the interest would be at least 6% per annum. Learned advocate, appearing on behalf of the United India Insurance Company Limited, Mr. Paul submits that both the vehicles were though involved in the alleged accident, but the charge sheet was submitted against the present appellant insurance company. So the learned tribunal has correctly awarded compensation and directed the present appellant insurance company to pay the compensation. So, for the learned advocate, peruse the materials on record. Also peruse the observation of the learned tribunal. It appears that the claim case stated the fact that both the vehicle were running dangerously and recklessly at the time of accident, and it has also been stated that both the vehicle collided, both the vehicle dashed the motorcycle of the victim. Stop. Eyewitness also disclosed the fact that drivers of both the vehicles were responsible for the accident. FIR was lodged stating that both the driver of both the vehicles were responsible for the accident. However, charge sheet was submitted against the present appellant. Considering the entire facts and circumstances of this case, it appears to me that the present appellant may have the liberty to prefer a specific application to proceed against the United India Insurance Company Limited to apportion the compensation in a separate proceeding. Full stop. However, in considering the submission of Mr. Singh, it appears to me that the learned tribunal has erroneously deducted 1/3 of the income towards the personal living expenses. The deceased was bachelor. So in this case, the deduction towards the personal expenses would be half. Full stop. The deceased was a civic volunteer. So the job of civic volunteer is not permanent in nature. Accordingly, the claimants are entitled to get the future prospects, which would be 40%. To the established income of the deceased. Learned tribunal has awarded parental consortium rupees 40,000. It appears that by virtue of decision, rupees 40,000. Full stop. It appears that by virtue of decision of the Honorable Apex Court in Pranay Sethi, the consortium is available to the spouses only. Thus, in my view, the learned tribunal has awarded excess 40,000 towards the parental consortium. In this case, the general damages would be funeral expenses and loss of estate. That is rupees 30,000. Mr. Banerjee submits that the 6 years has already been elapsed after the pronouncement of the judgment of Pranay Sethi. So 20% of general damages may be added in this case. Considering the submission, the 20% of rupees 30,000, that is rupees 6,000, is added to the general damages. Thus, the general damages in this case would be 36,000. Full stop. It appears that the learned tribunal has awarded 4% simple interest per annum on and upon the compensation. Full stop. This court has awarded several. This court has passed several judgments on the basis of the fact that each and every compensation shall carry 6% interest per annum. The same view may be adopted here. The incident, the award of this case shall carry 6% interest per annum from the date of filing of the claim application. After considering entire aspect, the award passed by the learned tribunal is hereby modified. Next, after calculation, the award comes to rupees 8,21,400. হ্যাঁ, চারটা করে। হ্যাঁ, চারটা নামিয়ে দাও। তারপরটা বলছি।
My lord requires this reference. Can you? Grateful to your lordship.
Yes. Okay. Yes, help us, sir. I'm not making any apportion here. Okay, that's why it is to be established. Okay. Observation is on the basis of the record. Nothing more than that. If they proceed, they would also place the record. Okay, I understand. The calculation, the award comes to rupees 8,21,400. Full stop. The present appellant, that is the Serum General Insurance Company Limited, is directed to pay the compensation along with 6% interest per annum from the date of filing of the claim application. Full stop. Next para. It appears that the appellant insurance company has already deposited a sum of rupees 25,000 at the time of filing. It was the statutory deposit at the time of filing of the claim application, and thereafter they have deposited a sum of rupees 14,51,823 on 22/8/2022. Thus, the insurance company has deposited total amount of rupees 41 lakh,
But 14 lakh.
14 lakh, 14 lakh 76,823.
Lordship.
823. Full stop. The said amount must have accrued some interest. Full stop. The Office of the Learned Registration High Court Calcutta is directed to disburse the directed to calculate the award passed by this court and disburse the same in favor of the claimants equally. Full stop. After such deduction, after such disbursement, there may have some residue in the account of the insurance company that may be refunded to the insurance company on usual prayer along with the accrued interest. Next para. The now whether you have paid the court fees.
If there is a deficit copy, I would pay.
Okay. The payment of compensation is subject to ascertainment of deficit court fee, if any. Full stop. The Office of the Learned Tribunal shall act upon the certified copy of this order to receive the deficit court fee, if any. Full stop. Next para. It appears that fact shows both the vehicles were involved in the alleged accident, and this court and the Learned Tribunal as well as this appellate court directed the Serum General Insurance Company Limited to pay the entire compensation. Next para. Now, by virtue of decision of Honorable Apex Court in Kenai versus New India Insurance Company Limited, the claim application filed by the insurance company against any of the tortfeasor is maintainable. Against any of the tortfeasor is maintainable. Full stop. Considering the ratio laid down by the Kenny, I am of a view that the present appellant, Serum General Insurance Company Limited, is liable to pay the entire compensation to the claimants, and they are at leave they are at liberty to initiate a separate proceeding regarding apportionment, regarding determination of apportionment and contributory negligence.
Not composite negligence.
Composite negligence. Percentage of composite negligence in respect of the other insurer and against the other insurer, that is United India Insurance Company Limited, in a separate proceeding. Court connected applications all disposed.
Indebted to one. Joint issue. Motion, Kochi.
Item number 3.
Milord, item 3 is the appeal of insurance company. Milord, it was taken up by your lordship, Milord, on the last day before. Milord, where the leave under section 170 was not taken. Joint Tutamake Dakla. My lord was of the view, Milord, in view of my lord's earlier judgment, Mithu Sheikh, if my lord remembers correctly, when the leave under sections 170 has not been taken, Milord, insurance company is not entitled to take any defense, Milord, on quantum or Milord on anything other than 149(2). Milord, this award was ex parte. So, Milord, obviously the question of taking leave under 170 did not arise. Milord, we were thinking, Milord, that perhaps, Milord, we would withdraw this appeal from liberty to your lordship, with the liberty to your lordship, Milord. But somehow, Milord, it did not work out. So, Milord, I'll argue this case before. I'll pray before your lordship, Milord, to revisit my lord's own judgment. Milord, I'll start it today itself. Milord, one humble prayer. Milord, item number 19 in your lordship's today's list.
90.
19.
Okay.
Is also, Milord, a separate appeal of insurance company. 19.
Yes.
Milord, this was also, Milord, mentioned before your lordship for upgradation on the sole ground that 170 leave has not been taken.
Okay.
So, Milord, in this 19, Milord, item number 3, Milord, is ex parte. Milord, nobody is on the other side. But item number 19, Milord, Mr. Jayanto Banerjee, Milord, he is appearing on behalf of the claimants. Milord, in 19 also, Milord, as I stated earlier, there was no leave 170, but Milord, at least insurance company appeared in 19. But in item 3, insurance company did not appear. So, Milord, I was only praying, Milord, your lordship will take up 3 and 19 together. Milord, so that, Milord, at least Mr. Banerjee would be there. Because, Milord, the point, Milord, I would be limiting my argument, Milord, only on 170. Whether without taking leave under 170, can insurance company take the other defenses or not?
Yes.
Because 149(2) defense, my lord has already held that yes, it can take. Whether you take leave, you don't take leave. But in additional defenses, Milord, in addition to Milord 149(2), whether insurance company is entitled to or not, Milord, I'll address my lord on those issues, Milord. Milord, 3 and 19, Milord, to be taken together. Before that, Milord, item 4 to 14, Milord, these are small applications, Milord. If it can be disposed of, then your lordship will, Milord, take up 3, Milord, I'll start argument today itself. 3 and 19 together.
Let the 3 and 19 be fixed after vacation.
Milord, I was ready. Milord, so that, Milord, no blame comes to me, Milord, because
No, there is no blame.
In that case, my lord, you logically fix the matter Friday morning as per stated. Hearing day, no problem, my lord.
Updated here.
Friday morning.
Friday morning.
Mr. Singh, you are ready?
Milord, I'm ready, Milord. Whenever my lord pleases, Milord, I'll start. It will take a little time. Not only, Milord, that the other matters do not suffer, Milord. I was trying to, Milord, because it will take some time, Milord. I'll place some judgments. So Friday morning, yes, Milord, I am okay with that. If my lord is, if my lord is, Milord,
So please take down.
ready enough.
Let the item number 3 and item number 9 be fixed.
19, Milord.
19 be fixed under the heading of hearing.
Yes.
On Friday.
Lordship.
is 17th.
17th, no, at the top, first matter.
17th at top.
I'm extremely obliged to your Lordship, Lord. I'm grateful to my Lord for giving me this opportunity. दो एक judgment दिखाना.
Item number 3 and 19. Yes.
Item number 6.
Mr. Singh for the appellate.
Also,
And Lordship,
Are you?
and Lordship also, and the instance of Mr. Singh, the matter today. Kindly,
the instance of Mr. Singh Miller, I always concede to whatever they pray.
that is repeating last word. This was also, I am keeping the paper book that has staff of Mr. Singh. That is the, I feel that is the only the point of quantum, because of the appeal of Mr. Singh can start proceeding.
My Lord, this is the, may I?
Yes.
So this is the appeal of insurance company. My Lord, it was upgraded, my Lord, so that only, my Lord, the point of quantum was involved here. And we, my Lord, humbly prayed before your Lordship, not it can be disposed of, subject to my Lord's pleasure. My Lord.
Yes.
May I? My Lord.
Yes.
My Lord, one gentleman, my Lord, around 24, 25 years old. My Lord, he was dashed by one Maruti car. My Lord, he died. My Lord, the widow, minor son, and the parents. My Lord, they were the claimants. Learned tribunal judge, my Lord, awarded rupees 21 lakhs 8,000 as principal compensation. And my Lord, there was interest. But rate of interest was not fixed. It was left in limbo, my Lord.
Banking interest.
Yes, my Lord, banking interest, my Lord, but the rate was not decided. So that is
was-
also, my Lord, we are one of the reasons, my Lord, it should be clear, it should be unambiguous, it should be explicit. Learned tribunal judge went wrong. My Lord, your Lordship will kindly decide that today itself.
Yes.
My Lord, the other points, my Lord, what I have taken in this appeal. My Lord, 21 lakhs, my Lord, as I stated earlier, was the principal award. My Lord, I have deposited the entire awarded sum with interest before my Lord's court.
Within the 6%.
My Lord, your Lordship, my Lord, had, my Lord, been passing orders, my Lord, to deposit the awarded sum with interest in most of the cases. In this case, my Lord, since there was an ambiguity, my Lord asked my client, my Lord, to deposit it with the interest. My Lord, I have deposited that with interest. My Lord, so principally 29 lakhs, odd amount has been deposited. My Lord, I have joined issues herein, my Lord, on the point of quantum, my Lord, on 4 grounds. My Lord, first of all, my Lord, learned tribunal judge considered, my Lord, the monthly salary of the deceased,
Yes.
who was alleged to be a mason, 8,000 rupees. My Lord, accident of 2016,
8,000.
Lordship, my Lord, 8,000 per month.
Yes.
My Lord, accident was of 2016. My Lord, so without getting into any nitty-gritties, my Lord, and without troubling a Lordship, my Lord, the plethora of judgments, my Lord, I'll pray it should be 5,000. That was the first issue, my Lord. My Lord, second point, my Lord, there were,
Date of accident?
my Lord, date of accident, my Lord, is the 16th February 2016, 1/6.
Yes.
So, my Lord, on that basis, my Lord, I say, my Lord, since there was no documentary evidence, it should be 5,000. My Lord, second point, my Lord, the learned tribunal judge, my Lord, deducted 1/4
Yes.
from the income of the deceased. My Lord, on the ground that there were 4 claimants. My Lord, as I stated earlier, my Lord, the claimants are widow, minor son, and parents, which includes the father. So, my Lord, Sarla Verma read with Reshma Kumari, read with Pranay Sethi. My Lord, I say, my Lord, deduction should be 1/3.
Yes.
My Lord,
Yes.
as far as, my Lord, the consortium part is concerned, my Lord, general damages. My Lord, in general damages, a total sum of rupees 2 lakh, কত? 40? 2 lakh. No, given extra under spousal, parental and
70,000.
My lord, your lordship will kindly see, my lord, the award. Page 48, 49, my lord, of the paper book.
Yes, 60,000 and 50,000.
Last two lines. Petitioner number 1, widow, gets spousal 50. Petitioner number 2, minor, my lord, next page 49, gets 60. And petitioner number 3 and 4,
50 each.
50 each. So, my lord, as I was stating earlier, my lord, 50 plus 60 plus 1 lakh, 2,10,000. My lord, this should be restricted, my lord, to 70 or my lord, to 77 or 84, whatever it is. This 2,10,000 should be brought down. And my lord, fourth was, my lord, the rate of interest is to be decided by a lordship. It should not be left. My lord, these are the 4 points. My lord, may I just, my lord, am I clear to your lordship? My lord, I'll just, my lord, invite my lord, to take the evidence part. My lord, the evidence of the widow is at page 17, 17. My lord, 17 is affidavit in chief. My lord, your lordship will kindly come, my lord, to the paragraph 7 last. That at the time of accident, occupation of my husband as a mason, under registered contractor, and my husband earned rupees 8,000 only per month. The name of the registered contractor, namely Ajit Dotai or Dolai, my lord. Residential address, village this, post office this, district this. This salary certificate issued by Ajit Dolai. Your lordship will take note of this last sentence. This salary certificate issued by Ajit Dolai. There is no such salary certificate produced before the court. Not even a single piece of documentary evidence is there. It has been stated on affidavit. My lord, next page. The time of accident, my lord, is there, paragraph 8.
Yes.
Time of accident, my age was 21. Age of minor was so and so. And petitioner number 3, my lord, that is, my lord, the mother, 46. And father, petitioner number 4, 53. My lord, now, my lord, the line what they're trying to harp on, all the petitioners fully depend upon the income of the deceased husband.
Yes.
They, my lord, take learned tribunal just considers that this is more than sufficient. So forget about Sarla Varma penalty, no evidence required, nothing else is to be stated. 8,000 to be granted, my lord, for monthly income, and deduction to be made 1/4. My lord, now your lordship will come, my lord. My lord, there are only 2 witnesses. One is widow, my lord. Widow, I have shown, my lord, what she has stated. And my lord, second one is, my lord, this eyewitness.
Okay.
There is no third witness. Eyewitness, my lord, is at page number 22. My lord, is there, my lord?
Yes.
Paragraph 1. That I know Dulal Dolai, resident of so and so. He knows. That's what he said. My lord, page number 1. My lord, page 22, page 23, page 24, cross-examination, page 25. Nothing is stated, my lord, even about his vocation. Forget about salary, forget about income. Even this is also not stated, my lord, that whether he was working as a mason. And a contradiction is there, my lord. I'll show that also to your lordship. at page 24. Page 22, I had shown your lordship note. I know the Dulal Dulai. Page 24, your lordship will kindly see last third line. I did not know Dulal Dulai before his death. Be that as it may, save and accept. My lord, that one line is statement of widow. My lord, there is nothing on entire record before your lordship, either to confirm the vocation or to confirm the salary or income by any means. Rather, I have shown to your lordship, note the widow says that I am, Milord, she gave some name and said that I am, Milord, filing or exhibit, whatever it was, Milord, this salary slip, which was not done in my written statement, Milord. I have disputed, your lordship, Milord, may I invite my lord to, Milord, page number 10, internal page 2. Paragraph 7, this is not admitted, my lord, is there, Milord, that the deceased was aged 24 or be a mason under registered contractor or his monthly income was rupees 8,000. So you come up with something, you say that you've got a salary slip and you say that you are going to file it. You do not do that. Only one line is statement that he was a mason or that he was earning rupees 8,000 per month. My lord would not do. My lord has, my lord, passed, my lord, at least, my lord, I would not give the numbers 300, 400, 500 judgments, my lord. Taking note of this, when, my lord, neither the vocation has been decided, forget about salary. You say that you have, and then you don't provide. So it is, my lord, on your part, my lord, you have suppressed if there was any. Insurance company has denied, my lord, whatever you have stated. And, my lord, in view of, my lord, Pranay Sethi and that with Salah Verma and, my lord, Rajesh Rajveer, my lord, Reshma Kumari, my lord, deduction should be 1/4. My lord, these were the 4 specific grounds, my lord. And, my lord, for that we mentioned the matter before your lordship for upgradation and, my lord, for disposal of this appeal.
Yes.
And, my lord, that eyewitness also, my lord, the contradiction, he said that I knew. If you knew, then why didn't you at least say that he was a mason? Or for that, my lord, he was working under so and so. Or for that matter, he was earning, my lord. At least it would have given some impetus, my lord, but nothing is there. My lord, these are my submissions, my lord. I am grateful to your lordship.
Yes, Mr. Dr.
Lordship of first submission advanced by Mr. Singh, the deposit the awarded amount. If lordship is directed to deposit amount along with 6% interest, then I have nothing to say because of lordship will decided the 6% interest. So I will make contradictory submission to that effect. If the direction is there. Because of there is I did not find any cross operation on the ground. The learned tribunal considered the part of interest and also observed that the banking interest. He also said that the interest as per banking rate as applicable. So what is the banking rate is going on that can be applicable. But even then there is the machines in the, so once it's directed to deposit 6%, then I have nothing to say on that score. And lordship, now second question is that the last tribunal decided the claim case by considering the monthly 8,000 per month. Lordship, kindly how the learned tribunal dealt with the issue. So kindly come to page 47. Second paragraph. The body of lordship is found.
Yes.
The body of the application under 160 MBA Act, there is a specific averment that the victim since this is used to 8,000 per month as a mason. So his wife says, his wife knows what is the avocation of his husband. And lordship kindly see that on that score, the insurance company did not dispute that avocation. Kindly come to the evidence of PW1. They did not at all put any question on that issue. Lordship kindly page 18, paragraph 7. Page 18, lordship, paragraph 7. As I'm reading. At the time of accident, occupation of my husband as a mason. He knows what his husband doing or do. Under registered contractor and my husband earned rupees 8,000 only per month. The name of the registered Ajit Dulai, that has been disclosed. But it's true that they did not produce any document on that score. But and lordship kindly see the cross examination as crossed by the chasing staff. What is that? I did not see the accident very well. My husband did approve. It is not a fact that my husband was not earning 8,000 per month. It is not a fact that the were not working under the contractor name Ajit Dole. There is no specific question whether your husband, what is the occupation of your husband? There is no specific plea. All along it has been proved. Because of wife said, my husband doing mason is a very common phenomenon, and doing mason and use rupees 8,000 per month. And also, I will justify how the learned tribunal considered the 8,000 per month, if at all, if it is proved that his husband is a mason. And lordship, the administration also take one the eyewitness. Eyewitness also did not put also same question to the eyewitness. Once you know, so you know the application. They did not put the specific question.
Eyewitness, that is PW2 said nothing about your question or anything. So why they shall ask the question? The PW2 in his examination in chief has not stated anything about the avocation and income of the.
No, he is the only eyewitness in him.
Yes, that's why what is the requirement of the arguing or examining him on the basis of the avocation?
No, that plea, they have taken that plea. Mr. Singh has submitted that. The eyewitness can also say that what is the avocation. That's why I am submitting. The submission of Mr. Singh is that the eyewitness also next said so. That's why I am saying that. So all along it has been proved that the husband was the mason, and it is the mason. And the lordship accident took place on 16 to 2006. Then lordship kindly see
2016.
2016. Then lordship kindly, I lordship kindly pardon me. I am not. I also have said to Mr. Singh, lordship skilled work. It is circular with the 2000 effect of 6 months, every 6 months the amount varies. The accident took place in February. So 1st January 2016 to 30th June, then it is if he is a mason, then lordship is skilled labor, then he will not come within the zone A because of the address of the petition Badaguri Govindpur district, Paschim Medinipur, Jhargram, so not municipal area, so cannot come in the zone A. He will come in the zone B. If the zone B, then his monthly income is appearing is 7,296. And definition of semi, unskilled and skilled, the definition is there. Also, I am reading the skill.
Whether that notification was considered by the learned tribunal.
But notification did not consider by the learned tribunal.
Yes.
But the learned tribunal considered the amount that's matching with the minimum wages act. If suppose that is not matched with that, then I could have filed a cross objection with that effect. But ultimately, I am justifying the learned tribunal ultimately, without considering the law, it is not that lordship, if law is not considered, but ultimate come to a right conclusion, that cannot be said that this law has to be written in the judgment. It is not that. But lordship, the learned tribunal considered if the mason lordship is the mason, class 1 is a mason, it is a skilled worker. So I also send that to Mr. Singh. Mason also skilled worker. Right? Page what? Skilled workers. Diesel rate thereafter. So if the mason 8,000, not 8,000, it will get some amount plus 7,296. Not 8,000. That is also true. I should say. So it is 7,000 because of his address is possibly found. Whatever Govindpur district, Paschim district, Jhargram, municipal area not mentioned. Even then, it will not compare. Obviously, it's not corporation area. So it will go. So learned tribunal partially not wrong. If lordship to that extent will go, then 800 rupees given extra. Only 2,296, 8,000. So 800 rupees more, less than 800 rupees, 7,000 something, 700 something has been given extra. Lordship, can you pardon me? I have no hard copy. And Lordship also decided the issue, the same issue. Lordship decided. He said by considering the minimum wages act, where that the tribunal also did not consider the minimum wages act. But ultimately, the award passed by the learned tribunal is matching with the award as passed by the learned tribunal. But ultimately, Lordship will decided that that is the case of Lordship. That is the case of 2018. The Lordship also decided that the minimum wages act, the award has been considered. But here Lordship kindly see that the minimum wages act 7,260 if you will come on the zone B. Then I cannot claim is the come on the zone A. So that if I go to that extent, so some amount has to be reduced because of 8,000 and 7,296. And Lordship, the learned tribunal, they did not adduce any rebuttal evidence, no contradictory evidence, nothing, and no independent witness with the regard. No, this has no application with that effect. And as the being a wife, also come before the learned tribunal, he also disclosed the entire. He could not have disclosed that the name of the employer, but he also disclosed. But unable to prove any document. That's true that whatever the evidence available on record, I cannot go beyond that. But Lordship, he has come with the tribunal. He has said, "It's my husband, the matter." And ultimately, the learned tribunal dealt with the issue without any contradicted evidence, without any rebuttal evidence. Yes, it appears from the claim application that the PCB government that victim since this is 8,000 per month. The application never challenged. No independent witness. And even then, they have taken a plea in the written statement. The duty of the parties to whatever plea you have taken in your claim, that this is their claim. Whatever point you have taken, you have to prove. So we have taken the plea. Suppose Lordship,
plea was taken by you. You are arguing otherwise.
No, Lordship, my humble
you have a specific plea that you are under avocation of specific avocation under a specific contractor. The name of the contractor was also stated in the claim application. But why you withheld the certificate? You must have produced the
certificate. Not withheld. Perhaps by any means, Lordship can understand what is the actual our village. He unable to produce. It's true. I can go beyond the record. But avocation is
the proceedings is yours. You have to prove the plea.
I prove. Yes, I said it's my husband used to work as a merchant. That I've said. And learned tribunal accepted my plea. There is no contradictory evidence on this regard. But oral evidence also a piece of evidence.
Yes.
This cannot be denied. But they said they have taken a plea in the written statement to contradict it, but they did not prove the written statement by producing the evidence. If they are unable to
no. You cannot argue like that. They just deny your pleadings.
Yes, there's denial.
They just deny your pleadings.
Usual denial.
Yes, no, you have to prove your plea. Thereafter, they are onus to disprove by placing the evidence. This is the law.
There is an evasive denial. So they were evasive denial. Everything they have denied. But it is not that they did not take a specific plea. Or if they take specific plea that he is not at all a merchant, then he could have produced the evidence. But there is no evidence in support of the instance. But a single evidence in the record. But whatever the evidence I have produced, evidence may be valuable or not valuable, that is decided by your lordship. But on my evidence, the learned tribunal come to a conclusion and decided the issue. But if they have prepared an appeal, they are basically appeal is against the knowledge of the judge. So what is their allegation? How the learned tribunal is wrong? If you have proof that you place the document, is the learned tribunal wrong in such a way? The learned tribunal should go, ought not to have gone beyond the evidence. They should go within the evidence. The learned tribunal will within the evidence that the oral evidence of the wife is a specific averment which appears from the claim application. There is no debatable evidence. But what is the wrong part of the learned tribunal? In spite of the specific evidence, in spite of specific readings, the civils
don't have any specific evidence.
oral evidence is there. Is there lots of what is there?
Oral evidence is there. Their duty to deny it, they denied. That is only their duty and the onus according to the attending facts and circumstances of this case. If you produce the certificate, thereafter they are onus.
I am not able to produce the certificate.
Yes.
I
You have made a oral evidence, they have denied it.
I have
That is their duty only according to the law.
What the law is there, I cannot go beyond that. And what is the foreign logic, I will go by that.
Yes.
So I will not be disputing on that full logic. My humble submission is that the avocation of the deceased, the mason, and the wife has come from the inception. He stated that my husband is a mason. That cannot be denied in such way. They can deny, but if they deny, they could have proved. Is my statement is wrong.
Yes.
The untrue statement has made before the court of law. And if lawsuit the learned tribunal taken the 80,000 per month, then they could have said that cannot, that is beyond. Because of in support of the tribunal orders, I have also produced the government circular. It's the 1st January 2016. If he is a mason, then what will be the income? Is it 7,296? So Mr. Singh is correct on that score. The 8,000 is not amount is a proper amount. It should be 7,296. He can say submit. So I have no option. I have to accept that. And other part is lordship. That is the and lordship also consider by considering the minimum wages act and decide the issue. And lordship award that. I am not placing. I am not subject to that external lordship. And lordship other part is that the 2 lakhs 10,000. So that amount lordship I individual because I cannot say it is the right. With respect to the judiciary, my humble submission, kindly that part has to be modified. Only India will get 77,000. Other part lordship is absolutely correct. The last part of the judgment is 2 lakhs 10,000. I cannot say anything.
That's all.
Yes, lordship decided another case lordship, that is the case of lordship Salma Khatun. Here the father was selling as the balloon and something else. After that lordship, I have placed the minimum wage that circular by considering the lordship that there is no evidence whether the avocation was proved by a cogent document or evidence. That document also is not there. But here one plea lordship was slightly knocked down, and is that he said he's taken the name of the employer Ajit Dolai, but he not able to produce that certificate before the court of law. But even then, lordship, the avocation is under dispute, my humble submission. So if you come under dispute, the learned tribunal rightly accepted the avocation, and once the learned tribunal ultimately come to a conclusion, the avocation of the deceased is the mason, there is no contradictory evidence from the insurance company. They have very well shaken the entire evidence. All questions they have put, but they did not. They satisfied that this was the mason. That's why did not specifically they have put the question, challenge the avocation of the defense. Or the evasive demand also decide the evasive. So the appeal, Mr. Singh will succeed the appeal on the score of 2,10,000. So Mr. Singh will not say anything. I declare.
Okay, please take down. Yes, anything, Mr. Singh?
My lord, the questions what were posed by your lordships, my lord, I could not have used any better words. Not even one was replied for. I only take note of that. Not even one was replied for, my lord. All the questions which were raised by your lordship, my lord. So, my lord, I stand, my lord, with the arguments what I made before your lordship, my lord. I'm extremely grateful to your lordship.
Yes, Lord.
Instant appeal is preferred against the judgment and award dated 23rd September 2022, passed by the learned judge, Motor Action Claim Tribunal, ADJ 4th Court, Paschim Medinipur, in MSC case number 138 of 2016. Full stop. The brief fact of the case is that on 16th February 2016, at about 3 p.m., when the victim of this case, namely Dulal Dolai, DOLAI, was proceeding to his house, taking extreme left side of the pitch road, by walking. At the time, one Maruti Alto car being registration number WB 36A 7654 coming from Hatibadi towards Asui side, ASUI, with a very high speed and rash and negligent manner, dashed the victim from behind. Full stop. As a result, the deceased sustained grievous injury on head and his body, and thereafter admitted to the Gopivallabhpur Health Center. And declared by the doctor as dead. Full stop. The widow, minor son, and the parents of the deceased prepared an application under section 166 of MB Act before the learned tribunal for getting compensation on the ground that the accident happened solely due to the rash and negligent driving of the driver of the offending vehicle. The claim case was contested by the insurance company by filing written statement. Stop. Next paragraph. After hearing the parties and after receiving the evidences, the learned tribunal has awarded a sum of rupees 21,08,400 towards the compensation and directed the insurance company to pay the compensation together with regular banking rate of interest. Being aggrieved by and dissatisfied with the said award, the instant appeal is preferred by the insurance company. Full stop. Next paragraph. Mr. Singh, learned advocate appearing on behalf of the insurance company, submits that the instant appeal is preferred only to challenge the quantum of compensation as assessed by the learned tribunal. Firstly, he submits that the learned tribunal has assessed the compensation by fixing the monthly income of the deceased to be 8,000. There is no specific evidence regarding the income of the deceased. Thus, the learned tribunal has assessed erroneously. assessed the income of the deceased erroneously. It submits that in this case, this court has adopted views that when death is occurred in a road traffic accident in the year 2015 and above, the notional income would be 5,000. Mr. Roy, learned advocate appearing on behalf of the claimant, submits that the claim application stated the income of the deceased to be 8,000 per month as a mason under a registered contractor. Full stop. The name of the registered contractor, that is the employer, was also mentioned in the claim application. At the time of evidence, the widow appeared as PW1 and deposed before the learned tribunal that her husband was a mason and employed under the contractor, namely Ajit Dolai. Full stop. The learned tribunal has considered the evidence of PW1 and is of opinion that the evidence of PW1 cannot be denied regarding the avocation and income of the deceased. Full stop. Mr. Roy submits that the observation of the learned tribunal is not erroneous. There is no specific evidence or contrary evidence on behalf of the insurance company to disprove the evidence of PW1. He further argued that according to the Minimum Wages Act for the month of January 2016, the minimum wages for a mason within bracket skilled labor for Zone B, Zone B is 7,296. The learned tribunal, though have not considered the specific notification of the government of West Bengal, but the observation of income of the mason on that relevant period is not at all illegal. Not at all illegal. Full stop. He further argued that the learned tribunal has correctly observed that insurance company does not controvert the testimony of PW1. No, sorry, insurance company did not controvert the testimony of PW1 except mere denial. Full stop. Finally, Mr. Roy submits that the income of the deceased may be calculated according to the Minimum Wages Act, according to the notification of Minimum Wages Act for the relevant period. Are the learned advocates peruse the observation of the learned tribunal? It appears that during evidence of PW1, like a widow, she stated that her husband was a mason and was employed under the registered contractor, namely Ajit Dolai. Though during her examination in chief, he stated that one certificate of income was produced, but no such certificate of income was placed before the learned tribunal to prove the income of the deceased. However, it appears that the learned tribunal is of opinion that the evidence of PW1 as well as the specific averment in the claim application may be considered the avocation, may be considered to be true as a avocation as a avocation and income of the deceased. In considering the entire materials and pleadings of the parties, it is the clear observation that a party has to plead regarding a particular point, and such point has to be proved by adducing proper evidence. In this case, the the claimant has pleaded that the deceased used to earn rupees 8,000 under a specific registered contractor. During the evidence, PW1 has deposed according to the pleadings. Such pleadings of the claimant was denied specifically in the written statement by the insurance company, and during the cross-examination, the oral evidence was denied by putting specific question. However, it is true that the insurance company has not asked anything regarding the avocation of the deceased, but the income of the deceased has been specifically challenged. Considering the entire facts, I am of a view that the learned tribunal has proceeded irregularly to consider and appreciate the evidences on record. Only by placing reliance upon the pleadings and examination in chief of PW1 is not sufficient to prove the specific income of a deceased. On the above score, I am of a view that though the avocation of the deceased was not challenged by the insurance company, but the income was specifically challenged in this case. Next para. It is the submission of the Mr. Roy that the learned tribunal has correctly assessed the income of the deceased, which is at par with the, which is nearly at par with the notification of Minimum Wages Act for the relevant period, that is 1st January 2016. It appears to me that the said notification was not considered by the learned tribunal.
There is a notification number and everything else.
Yes. It appears to me that the such notification was not placed or considered by the learned tribunal, and squarely it was not placed to challenged by the insurance company. Thus, now by placing reliance upon the notification to assess the income of a person would disentitle the insurance company to plead against it. Thus, I find no justification to place reliance upon the notification, which was not at all placed during the trial. Considering the same, I think it necessary to hold that in this case, as the deceased was a mason, so the income of the deceased should be calculated to be rupees 5,500 per month. On that score, the avocation and the score, the income of the deceased appears to me, income of the deceased calculated by the learned tribunal is requires modification. Next part. In considering the deduction towards the personal expenditure, the learned tribunal has deducted 1/4, considering the number of the claimants. In this case, the widow, minor son, and the parents are the claimants. So the number of claimants are 4. Full stop. There is no specific evidence that full stop karo. The among the four claimants, the legal heirs of the deceased are three, that is widow, minor son, and the mother. The father is not the legal heir of the deceased, and there is no specific evidence regarding the avocation and income of the father and how the father is dependent upon the income of the deceased. Thus, in this case, considering the number of the dependents three, the deduction towards the personal expenses would be.
They are on the score, Lordship.
Yes, I say there is no specific evidence.
Does it my petitioner put father-in-law, namely, also deposed on behalf of them, they are also referring same address, same mess. So 1/4 is the,
No, it would be 1/3. Yes, 1/3. Towards the personal expenditure should be 1/3 instead of 1/4. Full stop. It appears that the learned tribunal has awarded general damages of rupees 70,000 along with the 20% along with the additional 20% according to the observation of the Honorable Apex Court in National Insurance Company Limited versus Pranay Sethi. So the general damages was awarded rupees 84,000. However, it further appears that the learned tribunal has further awarded spousal consortium of rupees 50,000 towards the petitioner number 1, another 60,000 towards the petitioner number 2 as parental consortium, and rupees 50,000 each in favor of petitioner number 3 and 4 towards the filial consortium. The observation of the learned tribunal regarding fixing further spousal consortium, parental consortium, and filial consortium appears to me not justified according to the law declared by the Honorable Apex Court in National Insurance Company Limited versus Pranay Sethi. Considering the same, it appears to me that the award passed by the learned tribunal towards the parental consortium, spousal consortium, and filial consortium is not justified. Next para, it appears that learned tribunal has not awarded any interest on and upon the compensation. In this case, no, in this case, this court has on several occasions adopted the interest portion to be 6% per annum from the date of filing of the claim application. The same view can be adopted here. Thus, in this case, the claimants are entitled to get the compensation together with 6% interest per annum from the date of filing of the claim application. Claim application till its realization. Full stop. Considering all aspects, the award passed by the learned tribunal requires modification. Next part, the just and proper compensation is assessed as hereunder. Next part. After calculation, the award comes to rupees 10,12,800. Full stop. The award shall carry 6% interest per annum from the date of filing of the claim application till its actual realization. It appears from it next para, it appears that the insurance company has deposited an amount of rupees 25,000 towards the statutory deposit on 13/2/2023, and thereafter they have deposited further amount of rupees 29 lakh 9,000 315. So the insurance company has deposited in total amount of rupees 29 lakh 34,315. Full stop. The same amount must have carried some interest, must have accrued some interest. Accrued some interest. Full stop. The Office of the Learned Registered General High Court, Calcutta is directed to calculate the award passed by this court and disburse the same in favor of the claimants, in favor of the claimant number 1, 2, and 3 equally within 4 weeks. Full stop. After such disbursement, there may have some residue that may be refunded to the insurance company on usual prayer. Full stop. The payment of compensation is subject to ascertainment of payment of deficit court fee, if any. The Office of the Learned Tribunal shall act upon the certified copy of this order to receive the deficit court fee, if any. FMA connected can applications. FMAT দেখে নেবেন are all disposed of.
Extremely obliged.
Can make it only Sifal check to issued in the name of Sifali Tuloi. Otherwise, there will be some problem. Kindly add one line.
That is respondent number 1.
This is one. Sifali Duloi. Dondopati is the carrying the fathers at
Whether any application is there?
no loss. No application.
Okay, very good. লিখুন ওখানটা ওইখানটা ওই যে করেছি না disburse in the name of claimant number 1, 2, and 3. Respondent number, claimant number 1, 2, and 3 equally. Full stop করুন ওখানটা 4 weeks. Full stop করুন এখানে একটা অ্যাডেন্ডা করে দিন একটু। The Learned Registered General High Court, the Office of the Learned Registered General High Court, Calcutta, shall disburse the check in the name of applicant, name of respondent number 1 as Sefali Doloi. Whether the minor, whether the respondent is the minor, now minor.
No,
Yes, he would be minor because he was 2 years old.
2 years old.
And in 2016.
We can add Sefali Doloi. Sefali Doloi টা না invert comma দিয়ে রাখুন। Disburse the check in the name of Supervisor. The Office of the Learned Registered General High Court, Calcutta, shall also allow the said respondent number 1 to receive the check of respondent number 2 as his natural guardian mother, and he is directed to respondent number 1 is directed to deposit the check in a nationalized bank or post office in a fixed deposit scheme so that the amount may be utilized by the minor after attaining his majority. এটা ঢুকিয়ে দেন বেশ
Obliged to ma'am.
I'm obliged. Thank you, Kudu.
Upgraded matters, item number 7. In this matter, I am advocating for the respondent claimants. I have already filed one for cross appeal also.
Where is Mr. Mojumdar?
Yes, my lord. I am for the appellant. My stay application is on board. I have already deposited the statutory amount of 25,000, dated Challan 3528 on 24th of January. And I believe, my lord, the appeal is within time. So I have not preferred any section 5 application.
Give me your copy of challan.
Yes, ma'am.
There is no noting like that.
Xerox copy challan.
Okay, please take down. The incident appeal is preferred against the judgment and awarded date 6th October 2023, passed by the learned judge, Motor Accident Claim Tribunal, ADJ First Court Contai. In MSC case number 10 of 2016, the insurance company has preferred the instant appeal against the award. Stamp reporter suggests that the appeal is preferred in time. Suggests that the appeal is preferred in time. Accordingly, appeal to formally admitted, register the same. The stamp report, it is the report of the stamp reporter. The statutory deposit has not been made by the insurance company. Has not been made by the insurance company. However, Mr. Mojumdar has placed the copy of challan wherein it appears that the insurance company has deposited rupees 25,000 VDOD challan number 3528 dated 24/1/2024. Full stop. Mr. Banerjee appears next. Mr. Banerjee appears on behalf of respondent number
1 and 2.
Respondent number 1 and 2.
Claimant respondent 1 and 2.
Claimant stroke the respondent number 1 and 2.
So I filed one cross appeal.
Okay.
Cross appeal number
Mr. Banerjee
41
further submits that the claimants have also preferred a cross appeal being court number
41.
Court number 41 of 2024. Let the appeal, let the court 41 of 2024 be tagged with this instant appeal. Whether you shall prepare the paper book?
Your Lordship,
Shall you prepare the paper book? Otherwise, I have to direct the insurance company to prepare the paper.
let me deposit the amount, Your Lordship, for this court.
That is the another issue.
Your Lordship, the service of the notice upon the owner respondent be dispensed, Your Lordship, because
Whether you have received the
I will prepare the paper.
okay.
I've got a copy.
My lord, I would be insisting upon serve upon the owner because my
owner. Very
cardinal issue is implantation of the vehicle.
Very Mr. Banerjee, learned advocate, appearing on behalf of the claimant, submits that they received the certified copy of pleadings and proof. Pleadings and proof from the office of the learned tribunal, and if directed, he is ready to
No
prepare.
such point was taken during the examination.
Okay. Kyola. ready to prepare the paper, informal paper for the speedy disposal of instant appeal. Considering the submission, the LCR is not required to be called for from the office of the learned tribunal for the time. Stop. The respondent number 1 and 2 is directed.
Can you call for the LCR?
You require the LCR.
Since my landed friend is taking the point, you see the vehicle is implanted, so LCR is required.
তাহলে কি বললাম? Considering the submission টা কেটে দিন। Let the LCR be called for. After reaching the LCR, the department shall verify the same. On verification, if it is found to be complete and in order, the LCR be tagged with the instant record. The respondent number 1 and 2 is directed to prepare the informal paper book, at least 3 sets in number, containing all pleadings and proof of the LCR, and file the same after serving a copy of the same to the learned advocate for the appellant at the date of hearing of this matter. Full stop. The next paragraph, the notice of appeal upon the respondent number 1 and 2 is dispensed with. However, the insurance company is directed to serve the notice of appeal upon the respondent number 3
Fix a date after application.
by putting up a Tolobana cost, along with reading of notices form to the concerned department. Within first week after vacation. Within first week after vacation. Can 1 of 2022. This is an application for stay of operation of the impugned award dated such and such date. No caveat has been reportedly lodged. Full stop. Learned advocate for the insurance company submits that the insurance company has deposited the statutory amount of rupees 25,000 with the office of the 25,000, and insurance company is further ready to deposit the entire awarded sum for the purpose of speedy disposal of instant appeal. Mr. Mojumdar, learned advocate appearing on behalf of the insurance company, submits that if the award passed by the learned tribunal is executed, the sole purpose of the instant appeal would be frustrated. So he prayed for an order of interim stay. Next, considering the submission made on behalf of the insurance company and considering the readiness and willingness on behalf of the insurance company, there shall be an interim order of stay of the impugned award dated such and such till 19th of June 2024. The insurance company is directed to deposit the entire awarded sum together with 6% interest per annum, less the statutory deposit within that period. If such deposit being made, the interim order passed by this court shall be extended till the disposal of the instant application. Full stop. Failing which, failing which, the interim order shall be vacated automatically. Next, on such deposit, the office of the Learned Station High Court Calcutta shall invest the same in a renewable fixed deposit scheme. Full stop. Let the matter appear under the heading of application on 26th of June.
Yes.
I'm great.
Insurance component evidence copy. Also, only one thing also can we guide my landed friend to serve me a memo of that.
Yes,
Copy of the memo.
I'll serve a memo.
Okay. Better than the memo. I did not mention. 4:30. Praying for notice. 4:30? 4:30.
My lord, I am for not.
434.
No, not. Not this week.
Madam. अभी तो 2 p.m. fixed আছে তো
434. You are appearing for the petition. For the petition.
we are for the university Vidyasagar University.
Not this week. Or after the vacation.
After it.
Okay, after vacation.
Now
34 after vacation.
Fixed matter at 2 p.m. 4:32.
petitioner number respondent.
For the petitioner, madam. Okay, spread. And this my lord pertains to my lord, Mr. Bilodal Bhattacharya is appearing for the respondent number 6 and 7, my lord. That is the college, my lord. My lord, main answering respondent. He has some, my lord, difficulty, my lord, but today, my lord. May it be taken up subject to the convenience of the court after the, my lord, vacation, my lord. But this is long
The
pending.
petition.
This is a long pending matter, my lord. Very long pending matter. My lord can see from the title itself, my lord.
WPA 2020.
My lord. But here the petitioner, my lord, wanted a reinstatement in the service. But if my lord, senior my lord is on leg, my lord, I will not stand it. আমি কি এটা বলে নেবো জজের রেকর্ড ছোট মতো
Okay, after vacation. About the affidavits.
It is
It has been exchanged.
affidavits have been exchanged. Everything is ready. Everything is on record, my lord. We have also exchanged amongst ourselves.
So hearing can be done.
Yes.
Okay.
Can I just beseech your lordship, my lord, can it be, my lord, subject to convenience of my lord senior friend there on that side of vacation, my lord? Since lordship, my lord, takes it up on Wednesday. So, my lord, can it be on my lord,
12, 19 or 26. It would be appear on 12th.
12th at 2 p.m. my lord, can it be? Or na korte paro 12th of June.
12th. That is the first day of after vacation.
No, 10th is the first day. Subject.
I know the in this
No,
matters
first
I'm
day of
taking
the
the
hearing matter. So let it be on 19th June. 19th. Subject to lordship's business my lord permission.
Okay. 19th June.
But at 2 p.m.
2 p.m.
Grateful. So grateful, my lord. So grateful.
19th June.
May an order be passed, my lord?
Okay, very good.
And my lord, let this matter. I'm sure that my learned friends will be, my lord, agreeing to this. My lord. Let it be, since my lord, this has been matter has been heard previously also. Let it be, my lord, kept as a hard in part. My lord has
No,
my lord,
it would be otherwise
has
difficult.
not yet been
If
heard.
the determination change, then the difficulty will become.
Right.
Okay, please take down. Affidavits have been exchanged between the parties. The matter is otherwise ready for hearing. Let the matter fixed on 19th of June 2024 at 2 p.m. as a specially fixed matter.
So grateful. So grateful. Fill up on number 3.
Yes. Seventy-five.
Item 431.
The petitioner, my senior Ms. Devjani Shungupta is on leg. She will be coming. Short pass over, madam.
Okay, pass it over.
431. 433. 433.
Okay, first call.
First call. 435 and 436. 437. 438.
439, 440. Second call. 431.
It is passed over. Next.
433.
Give me the papers.
Second call. Acha, acha, acha. My lord, appearing for the petition.
Item number?
Item number
431.
না, বোধহয় 431 হচ্ছে না, 433 হচ্ছে।
Possible.
কোনটা হচ্ছে?
431 was possible.
First one, 431.
Meeting আছে দেখো তো আমার।
Have you served notice?
Yes,
Who
my
is
lord.
appearing on behalf of the respondent?
My lord, Mrs. Tapati Samanto is appearing for the respondent. We serve notice upon him on 13th March 2024. It was served on 14th March. Well, am I to serve once again a notice?
Direction is there. You have served the notice again. How many times you have to serve?
Yes, my lord. My lord, this is the notice given to the learned state advocate.
Affidavit in opposition has been filed.
আমাদের
Affidavit in
reply-
opposition, affidavit in reply, everything is ready.
Everything is ready. Okay.
Whether they are in the panel,
No, my lord.
this is difficult.
No panel. My lord, this is regarding for granting the postgraduate scale of pay. The petitioner joined the school. My lord, he is an assistant teacher of the school. At the time of joining the school, she was having the postgraduate qualification. And my lord, that is why she is praying for postgraduate scale of pay commensurate with her postgraduate qualification. My lord, she is an assistant teacher of Calcutta Deaf and Dumb School. And it is also their circular that the teachers having the appropriate qualification of postgraduate in Calcutta Deaf and Dumb School, they will get scale of pay according to their qualification.
Now,
And-
at the time of appointment,
Yes,
who
Milord.
are appointed under the postgraduate? No.
Milord, this is not covered by School Service Commission appointment. These are all direct appointments I am submitting, Milord. Milord, this special school, the schools for special children, they are under the Mass Education Extension Directorate.
Okay.
And the teachers who are appointed through School Service Commission, they are appointed in the schools who are controlled by the School Education Department. So, Milord, this Mass Education Extension Department has two directorate. One is Mass Education Extension Directorate, another is Library Services Directorate. Now, Milord, this Mass Education Extension Directorate, they deals with these all special schools, that is the schools for hearing impaired, visually impaired, the mentally retarded, and in those schools, there was no selection through School Service Commission. They are outside the ambit and scope of examination of School Service Commission.
Okay.
Here, the Mass Education Extension Directorate, they gave the approval for appointment. Appointment is given by the school. And thereafter, the appointment of the petitioners, these are also approved by the Mass Education. So, panel is also approved by Mass Education. And, Milord, the appointment is also given by the Mass Education Directorate.
So at the time of appointment,
yes, Milord, nothing is mentioned. The qualification is mentioned, but there is no such group that this is the postgraduate category, this is the graduate category. There is no such group in the said schools. Milord, at the time of advertisement, the minimum qualification is mentioned there. And thereafter, as and when the petitioner, sometimes they have joined with the higher qualification, and sometimes they acquired subsequently the higher qualification. So, Milord, accordingly, according to ROPA, according to all these memorandums, when they are paying for postgraduate scale of pay, that scale of pay is given to them, and several instances are there. I have annexed those documents in this writ petition also.
So what you have done there? Why you are here? Have you made any representation there?
Yes, Milord. Milord, the representation I made, and that was refused by the director of Mass Education. That I have annexed.
Refer me the annexure.
Milord, that is at annexed. I am telling you. Page 101. 101 টা কি আছে? না, 101 নয়। Later of this one, issue 63. মামলা ধরে গেলে মুশকিল। Well, I'm giving the date, Milord. তো দেখছি 63 তো দেখছি 63 তো দেখছি এটা তো রিপ্রেজেন্টেশন স্কুল ডাইরেক্টরেটকে পাঠালো ছাড়ো ছাড়ো Yes, Milord, that page 63 is the rejection order.
This 2-line order.
Yes, Milord. If my lord so desire, there may be, Milord, a direction upon them to consider my representation. Milord, I have given a detailed representation and to pass a reasoned order. I think, Milord, this is, we do not know what was playing in their mind. There should
What
be.
What is the answer?
This is the 2-line answer.
Subject stated above, she is hereby informed that clause 16.3 ROPA rule is not in existence.
Yes.
What is the answer?
Milord, clause 16.3 of ROPA rules 1990, Milord, that has given the provision of
awarding higher scale, my lord, in commensurate with higher qualification.
No, this is the representation. This is your representation dated 8/8/2018.
My lord, yes, 8/8/2018. That is page 62. Page 62. Representation. আরেকটা রিপ্রেজেন্টেশন হয়েছে বোধহয়, দেখো তো ওখানে। দোষ পিছুতে আছে, পরের দিকে হবে, আগের দিকে হবে কেন? নয়, ডিপ পড়বে না কোর্টে এসে সব। My lord, we have a detailed representation at page 109.
Order was there by this court, by the coordinate bench of this court on 17th of August 2018, page 104.
No, that is 104. That is another order. These orders are, my lord, I have annexed in support of my claim. But in this case, there was no order. This is the first time.
Oh, this is the first time.
And this is, my lord, in case of another teacher, Chandra Chattopadhyay, who was also a teacher of that school and was a lower scale. And my lord, upon this matter, the higher scale was granted to her. My lord, may I submit one thing? My lord, this two-line order is really cryptic.
Yes.
My lord, I have made, Lordship, kindly grant me leave to give a detailed representation, and kindly setting aside this order, ask them to give a reasoned order so that we can challenge it in a proper perspective. In fact, my lord, petitioner given subsequently a detailed representation at page 109. That was 109. That was unanswered. 109, my lord. Detailed representation she had made, but that was unanswered. After this order was passed at page 63. In connection with this order, my lord, as detailed representation was made, and that is unanswered.
That is the annexure, page 109.
109, my lord, annexure P20.
So initially, what is your letter? 64, 63 is the, 62 is the your letter.
62 is the, my lord, representation which was considered by them apparently and passed the order at page 63. Now, my lord, in connection with page 63 order, a detailed representation was given at page 109 for consideration of all these views, but no answer was given and no further order.
Please take down. The present petitioner is the assistant teacher in Calcutta Deaf and Dumb School.
Yes, my lord.
At 293 Acharya Popullo Chandra Road, Calcutta 709. 7000009. Full stop.
'62 was the representation, my lord.
Yes.
By the representation, she paid for postgraduate scale of pay.
The present, it is the case of the present petitioner that she joined in the said school when? On?
My lord, 15th October 2007. 15th
October 2007. With?
MA in?
With master degree?
In Bengali.
In Bengali. Full stop. as her pay scale of pay is not commensurate with his higher higher scale commensurate with the higher degree, with the master degree. So he made a representation to the Director of Mass Education Extension Department, Government of West Bengal, on 8th of August 2018 for granting higher scale of pay in her favor.
Well, 2nd August 2018.
When?
First representation, page 61, 2nd August 2018.
Okay.
61, 2nd August.
2nd August 2018.
Yes, my lord.
For grant of higher scale of pay in her favor.
My lord, both 61 and 62.
Both 2nd August 2018 and 8th August 2018.
Yes, my lord.
Made two representation.
Two representations. One before the school and another before the director.
She made two representations to the principal and the Director of Mass Education Extension Department. What is as that? Follow? Government of West Bengal, respectively, for granting higher scale of pay in her favor. Full stop. Her representation were turned down by the authority by a cryptic order dated 4th of October 2018.
Yes, my lord. Page 63. That is under challenge in the writ petition.
In challenging such cryptic order, the instant writ petition was filed. Stop. It is the further case of the present petitioner that he also
109.
He also
made a detailed representation
regarding the ground which can entitle her to have an postgraduate scale of pay.
Yes, my lord.
To the concerned authority on 18th of January 2019.
Yes, my lord.
The authority till today did not respond the petitioner. Thus, the instant writ petition was filed requiring direction upon the authority concerned to grant the higher scale of pay in favor of the petitioner. Or the learned advocate for the petitioner. Peruse the representation made by the petitioner annexed with the writ petition as annexure P20.
And my lord, kindly take note of the government memo where it is stated that the teachers of Calcutta Defence School having higher qualification will get the higher scale of pay. That page 38 of the writ petition. The director also, page 38. Director also did not take into consideration that memorandum. 38. Government memo, my lord. Then the school was under education department. Then after demarcation, the new department, GO number 1102. From the Assistant Secretary of the Government of West Bengal to the Director of Public Instruction, in continuation of Government Order number 1026, the undersigned is directed by order of the Governor to say that the Governor is pleased to order that the trained MA, MSc, MCom and honors graduate teachers of the Calcutta Defence Dam School will be entitled to draw pay in the scale of higher qualification GO number 470 with effect from 1st April 1966. It is the definite order, my lord. And my lord, based on the other teachers got this.
The notification, no, during the argument, the notification of Government of West Bengal by GO number 1102 dated 13th December 1966.
Yes, my lord. Next page is the type page.
Is referred by the petitioners. It is referred by the petitioners for consideration. I have heard the learned advocate for the petitioners peruse the prayer of the instant writ petition. It appears to me that by virtue of notification number 1102 dated 13th December 1966, the
being annexer P6
within bracket annexer P6. Annexer P6 bracket annexer P6. The trained MA, MSc, MCom and honors graduate teachers of Calcutta Deaf and Dumb School were entitled to draw pay in the scale of higher qualification with effect from 1st April 1966. Full stop. The said notification appears to be not considered. Next paragraph. The said notification appears to be not considered by the concerned authority. Stop. None represent the concerned authority. Next paragraph. None represent the concerned authority at the time of hearing. Considering the situation, who is the respondent number 1?
My lord, it will be considered by the respondent number 2, the director.
Respondent number 2.
Yes, my lord. Space 2, my lord.
No. Next, considering the facts and circumstances of this case and considering the notification as mentioned above, it appears to me that the prayer of the present petitioner is justifiable in the eye of law. However, the concerned authority has not responded the present petitioner in respect of her representation dated 18th January 2019. Thus, at this situation, the instant writ petition is disposed of with a direction upon the Director of Mass Education,
Extension.
of Mass Education
Extension.
Extension Directorate,
Yes.
Government of West Bengal, being the respondent number 2, to consider the representation of the present petitioner annexed as a P20 of the instant writ petitioner dated 18/1/2019 in accordance with law for according her higher scale of pay commensurate to her
higher qualification
within a period of 8 weeks, within a period of 8 weeks from the date of passing from the date of receipt of this order,
And after giving an opportunity.
and after giving an opportunity of the petitioner of being heard. After giving an opportunity of the petitioner of being heard. Full stop. The decision of such decision, the concerned authority shall pass a regime decision within the stipulated period and shall inform the decision to the petitioner within 2 weeks thereafter.
And my lord, the order of the director is set aside at page 63.
According to the impugned order of the
Director of Mass Education, page 63. 63, my lord.
কি বললাম বলো? Impugned order dated 4/10/2018 passed by the Director of Mass Education Extension in response to the representation of the present petitioner. In response to a representation of the present petitioner is hereby set aside. Full stop. The
And my lord, in spite
respondent
of
number authority is at liberty to take a fresh decision on considering on all attending facts, circumstances, and notification of the government of West Bengal.
And my lord, the judgments passed in the earlier cases granting postgraduate scale or a higher scale to the other similarly placed teachers.
The law. That is
Yes. And my lord, in spite, losses kindly add that in spite of service of notice, no one appeared for state and no accommodation is paid for.
All attending facts, circumstances, notification, and according to law. Full stop. প্রথমে পড়ে দেবে একদম ফার্স্ট in spite of service of notice none represented the respondents. Actually the matter is taken up for hearing.
And no accommodation was paid for.
And no accommodation has been sought for.
Is grateful, my lord. Notice xerox.
Under the above direction, the instant writ petition is disposed of.
My lord, may I have a look to the notice and take a snap because we don't have a copy thereof, the notice.
Okay, this notice.
Notice. এটা একটা ফটো তুলে নাও।
Last তারাটা কি করলো?
এক্ষুনি we are giving back.
না তার আগে হ্যাঁ না ওটা একদম প্রথমে যেটা হয় বললাম না ওর আগে দেখো
Notice be kept with the record.
Notice upon the authority upon the respondent by the petitioner be kept in the record.
The photo তুলে just দিয়ে এটা নিন।
এটা হচ্ছে প্রথমে
আমরা শুধু নোটিশটা দিন, একটা ফটো তুলে নিন।
এটা নোটিশ কথাটা প্রথমে দিই, এটা বললাম লাস্ট
শুধু নোটিশটা একটু দিন।
in spite of service of notice তারপর
ফটো তুলে নেবে, এই তো প্রথম কথাটা।
প্রথম তারপর
এটা আমার 433
I'll find the respondent number 3, my lord. I'm led by Mr. Nilokpal Chatterjee of the university.
I cannot hear.
I'm sorry, my lord. My voice cracked, my lord. My lord, I'm for the respondent number 3 for the university, my lord. I'm led by Mr. Nilokpal Chatterjee. My lord.
Item number 433, my lord, I appear for the petitioner, my lord.
Yes.
Now, my lord, in this matter, my lord, what happened, my lord? There are three petitioners. Now, my lord, in these three petitioners were stopped from visiting the college, my lord, for 3 years. So this was done, my lord, in the year 2020. Now we have crossed 2024. So that order has gone. Now, my lord, we have challenged those order. My lord, subsequently, my lord, we want to pursue our studies. So, my lord, if your lordship kindly grants, my lord, on the previous occasion, your lordship directed, my lord, us to send a notice upon the college. Now, my lord, the advocate appearing for the college, Mr. Amitabh Chaudhary, has retired from the brief. So, my lord, I have to serve the college once again.
You serve.
The college is the answering respondent, my lord.
You are the answering
No, the
respondent.
college is the answering. We are the
College
respondent.
is the answering respondent, my lord.
Yes.
Sorry, one.
Please take down. Petitioner intends to serve the notice upon the college authority being respondent number 4 to 10. According the petitioner is directed to serve the notice to the college authority, informing them that the matter shall appear in the list on June 12th at 2 p.m.
Grateful.
Grateful to your lordship. The university is being represented, your lordship.
You give a name.
435 and 436.
আমাকে দিন ডিসমিস করতে রেখে কি হবে শুধু None appears on behalf of the petitioner on first call. On second call, no representation has been made by the petitioner and no accommodation is sought for. This matter is pending since the year 2022. It appears that on the earlier occasion, accommodations were sought for by the petitioners. Considering the conduct of the petitioner, it appears to be the petitioner is not at all interested to proceed with this matter. Hence, it is ordered that the instant matter be dismissed for default. তিনটে নাও 3 330 ডিভিশন বেঞ্চ কোথায় কত নম্বর 17 This step 200 কনফার্ম হয়নি কোথায় আছে কোন কোর্টে আছে এখানে না ওখানে কল দ্য লিস্ট
Item 437.
I beg to appear for the petitioner.
Yes.
In this matter, my lord, on 17th August 2022, there was a direction for filing affidavits by the state. No affidavit was filed, my lord. They sought for extension of time.
Again.
Sought for extension. Even then, they did not file. Now, last date, they did not appear also. So, your lordship directed to serve a notice. I have served the notice upon them, my lord, saying that the matter shall be appearing before your lordship.
Who is appearing for the
Mr.
state?
Shayok Chakraborty is appearing for the state, my lord. Claim is, my lord, petitioners are, my lord, they were initially engaged as part-time lecturers of, my lord, government polytechnics. Subsequently, from 2010 onwards, their designation changed. They were brought under a contract. Contractual, they've got contractual monthly remuneration. So the nature changed from part-time to contractual,
Yes.
but the designation of part-time continued. They called part-time contractual. A new designation was not given. They are continuing in that post for a long time. Now, from 2011 onwards, the government of West Bengal has introduced various finance department has introduced various circulars by which similar kinds of contractual workers and casual workers, they have been given some benefits. That if you are working for 10 years and more, you will get a particular pay scale. If it is for more than 15 years, you will get a particular pay scale. I'll annex that. I'll place that. So as per these circulars, we are entitled to get that particular pay scale given by the finance department. That was not given. Now we continued under the previous circular of 2010. The circular contained a clause that your terms and conditions shall be fixed in future, but nothing was fixed. So same remuneration continued for from 2010
No,
till date.
what was the memo of the finance department?
Yes, that is 2011, 16th of September 11 at page 141 of the writ petition. Basically, I am asking for benefit of this memo. Only the pay scale has been revised from time to time. It has been enhanced by the government. But we are stagnating at the same pay scale for a long time. Page 141 is the government memo. 141. Main dispute is they are treating us as part-time, but we are actually contractual. That is the main dispute, and we have annexed sufficient documents to show that we are contractual in nature, but no affidavit comes from them. The 2011 circular, 16th September, I am placing, in order to provide security of tenure, appropriate emoluments, and certain terminal benefits subject to fulfillment of certain conditions to the casual, delegated contractual. These are the three categories. Casual, delegated contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years in connection with implementation of various schemes, projects of various departments of the government to memorandum number so and so were issued by the government in finance department. The question of making the provision of the two aforesaid orders more effective and suitable to the convenience of the government establishments, organizations has been under active consideration of the government for some time past. Then the decision. After careful consideration of the matter and in supersession of the aforesaid orders and all other orders issued by the departments in the matter, the undersigned is directed by order of the governor to say that the governor has now been pleased to order that the casual, delegated or contractual workers who are remaining attached to various establishments of the government, departments, directorates, regional offices, other organizations for not less than 10 years continuously as on 1/8/2011 and have rendered service for at least 240 days each year will be allowed the following benefits. Casual, delegated contractual workers who have rendered 10 years of service with at least 240 days attendance each year may remain engaged in the same status and capacity till their attaining the age of 60 years. Continuity of service shall have to be certified by a competent officer not below the rank of assistant secretary in the case of a secretariat department, director in case of a directorate, and assistant engineer in case of regional offices. Concerned officers who certifies may be advised to exercise extreme precaution and take assistance of an office of WBA and AS if necessary. At entry point, basic pay in pay band 1, that is 6,600 rupees 4,900 plus 1,700 per month will be admissible to casual, delegated contractual group D workers as consolidated remuneration. Similar entry point pay in the pay band plus grade pay will be admissible to casual, delegated contractual group C worker and an employee of any other category if he or she fulfills the required condition. Will be entitled for a monthly remuneration which will be minimum entry level pay of pay band and grade pay corresponding to his or her category, and the remuneration may be determined in consultation with the finance department. We are group B, Milord. Lecturers, Milord, they will possibly group B. Oh, group A, Milord. We belong to group A, Milord. Now, it says that Group B, Group C, or any other category, it has to be fixed by this finance department. Then when such casual delegated contractual workers are allowed the entry point basic pay, they will not get any other allowance like dearness allowance, house rent allowance, etc. Their basic pay will be enhanced 5% every year. This is enhancement. Then 4, remuneration of casual delegated contractual workers.
Who are you? You are the whether contractual workers.
Yes, I am coming to that, my lord. Initially, we were engaged as part-time, page 30-32.
Part-time of what?
Part-time lecturers of the government polytechnics. Kindly comes to page 30.
Whether this notification
It applies. That is
covers.
Our humble submission is it covers, but they say that when we went to their office, they say that you are part-time. Since you are part-time, you will not get the benefit because it applies.
Part-time teachers are covered. They are the workers like
No,
that.
they are not. No, it says not any establishment. I'll place it once more. Kindly comes to 141 once more, my lord. Any establishment under the government. Paragraph 3. I'm reading once more, my lord. Paragraph 3 of page 141.
Yes.
After careful consideration of the matter and in supersession of the aforesaid orders and all other orders issued by the departments in the matter, undersigned is directed by the order of the governor to say that the governor has now been pleased to order that the casual delegated contractual worker who are remaining attached to various establishments of the government, departments, directorates, regional offices, other organizations for not less than 10 years. It has to be an organization under the government. I have to show that it's an organization under the government and I'm attached to the organization for more than 10 years. If it is not a private organization, I'll not get any benefit. But if it is,
you have made any representation?
Representation was made, my lord. It was not considered. Now, my lord.
Where is your representation?
Representation. Give me just a second, my lord. 16th of February 2022. Page tab. Just a second, my lord. Page 166, my lord.
166.
166 is there, my lord. আগেরটা হচ্ছে
The reminder in continuation of earlier dated receipt.
এটা কোথায় সবাই
Representation of 29%.
My lord.
All of the petitioners here.
Reminder, my lord, I'll just check up. There are total 29 petitioners, my lord.
29.
All of them.
All the petitioners.
All of them. Some developments, even after that, have taken place. The education department has issued a circular by which these kind of lecturers, they have been awarded some benefits, but those benefits are not at par with the benefit given by the finance department. So naturally, my lord, since the finance department is giving a higher benefit to all the establishments,
That is a notification.
that is, my lord, at page 152. This has been subsequently given to us, but this is much less than the finance department's benefits. Page 152. An order of the government of West Bengal under the Technical Education and Skill Development Department, dated 26th of February 2021. The matter for revision of remuneration and other service conditions in respect of contractual and part-time staff in government and government-sponsored Polytechnics engaged with concurrence of finance department was under active consideration of the government for some time past. After careful consideration, government under the so-and-so department has decided to enhance the remuneration as well as to allow certain benefits in the following manner.
Here the lecturers are contractual
And
and
part-time. Yes, they are treating us as part-time. But I say my petition is that you have recognized us as contractual and you have entered into a monthly contract with us. So we have become now contractual. The designation remains
Want the benefit
of
of
first
that
contractual,
notification?
contractual,
Contractual.
and my lord, the government notification. 2011 notification I have shown that is a higher benefit, my lord. I am entitled to that higher benefit.
So whether you have made any representation like that?
My lord, representation was not for implementation of the benefits. That was there. But they have
Not
after that
specified regarding the notification.
no. After that, they have not conferred the benefit of the notification of 26th of February 2021, page 152. That has been conferred upon us. That too part-time. So in effect, they have
now
not
receiving the remuneration as part-time.
part-time as per page 152.
As per page 152.
First is not you should be treated as contractual, and secondly, my lord, we should get the benefit of the government of West Bengal's finance department's circular. These are the two cases. Now, there a specific case has been made out that we are contractual and the nature of duty is like a full-time teacher. Part-time means a few periods shall be given, they will give us as per the classes. That was the previous system. But after 2010, we are whole-time employees. For the whole day, we are working.
Contractual.
Contractual, we become contractual. I'll just show you how we became contractual. I'll just show you that memo. Page 34 is the memo under which we became contractual. Page 34. Kindly come to page 34, memo dated 22nd September 2010. Memo number 557. Subject is implementation of contractual fixed remuneration of part-time lecturers. Implementation of contractual fixed remuneration of part-time lecturers. Under this, we were initially part-time. They implement contractual fixed remuneration. Now, after this, they give us kindly see the pay scale is also fixed. For rendering less than 4 years, 10,500. Rendering 4 years but less than 10 years, 12,000. For rendering over 10 years, 15,000. So this contractual rate is implemented to us. And this says the other terms and conditions in respect of such part-timers shall be decided later on. They don't decide anything. So this is continuing from 2010, this rate. 2021, they give us not this 151 benefit. But we say that since we become contractual, we get the benefit of not the government of finance department circular. This is the point, Miller, that we are contractual, we are entitled to the finance department benefits, which has been enhanced from time to time. And we have prepared one supplementary affidavit where not the department is not recognizing us as contractual. They are treating us, AICT has recognized us as contractual, and in their website, against our name, the contractual term is used. I have not prepared that supplementary also.
No, you have to serve the supplementary affidavit.
Copy serve. Yes, serve. Copy serve. Copy serve. Service to the
Copy served.
Yes. Copy served on the other side, subject to leave of your lordship's court. Unless leave is granted, I cannot use it.
What is the supplementary affidavit?
The supplementary affidavit, it kindly comes to page 5, my lord. We made an RTI application before the All India Council for Technical Education. There, kindly see page 5, appointment type contract. Kindly see, my lord.
In respect of All India Council for Technical Education.
Yes. So our name is, my lord, enlisted by the government of West Bengal. As per the enlistment, my lord, they are
ad hoc contract.
Contract. It says my appointment type is contract. Page 5.
Contract.
Contract. Appointment type contract. Because if it is a monthly remuneration, it has to be contractual. It cannot remain part-time anymore. Everybody is not treated as ad hoc contract. Page 6 is ad hoc contract.
Okay, I understand.
So this is the point rate. They are not conferring that benefit. And we shall give another notice to the advocate saying that matter was taken up. And no affidavit has been used by them. In spite of not 2-3 opportunities.
No affidavit is there?
No affidavit has been filed by them. Kindly see red global. First direction.
You serve notice.
Direction was passed in 2022. It was extended on.
What is the can?
Oh, some people have filed addition of party saying that we are also lecturers, we also are entitled to similar benefits. They are not moving. They have to file a separate writ application. They cannot get added here.
Supplementary affidavit filed on behalf of the writ petitioner is taken on record. The respondent is at liberty to file the affidavit in opposition against the supplementary affidavit within 6 weeks. Reply thereof, if any, be filed 2 weeks thereafter.
A shorter date may be given because we have not.
No,
2000
vacation is there, that's why I am.
No, direction was given, my lord, in 2022 August. They did not file it. Now, then on 12th of December, they sought for extension. Extension was granted.
4 weeks, 4 weeks, 2 weeks.
That is also expired, not. December 22, they sought for extension. That is expired. Now they are also not seeking for extension. They are not appearing.
4 weeks, 2 weeks. 4 weeks, 2 weeks. Matters shall appear in the list on July. 3rd July. No, 3rd, yes, 3rd July.
We shall communicate if no affidavit is used, not then.
Shall appear on 3rd July at 2 p.m. under the heading of special fixed matter.
Much obliged.
Full stop. The learned advocate for the petitioner is directed to serve the notice upon the
Only one, this chance is peremptory for them because 2 extensions have been given. Peremptory, a chance to file the affidavit, kindly make it peremptory because otherwise they will never file it.
No, let them appear. Let them appear. You serve notice, I will pass the necessary order. Informing them regarding the gist of this order.
Deeply obliged.
Lordship, one indulgence, Lordship, item number 436, it was on the last occasion, your Lordship has directed that it will be appeared on 17th. But suddenly it was found today at 3 p.m. I don't know, I am appearing for the state respondent. We have filed everything and only that matter, the.
Yes, it will appear on 17th.
17th, Lordship.
430, 17. Code number 17. Code number 17 হয়েছে তো?